So I think it's obvious what I need to talk about today, and it's the shocking release of a draft opinion by Justice Alito stating that the Supreme Court will overrule Roe v. Wade. Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So I know I'm a couple days behind the news here. It's just because it's just me doing this work. I'm really not in a position to be able to produce news on a daily basis the way that the other channels might be. But there's just so much to talk about with this decision. I had to take some time to at least reflect on it a little bit. The conservatives like to create this image that abortion is not something that's a concern to most women. And I guess to an extent that's true, but it's actually shocking what a high percentage of American women actually do get abortions. I read that about a quarter of women actually will get an abortion in their lifetime. And the average woman who gets an abortion is in her 20s and already has a child. So this image that's created of young, irresponsible people taking advantage of it really is a red herring. What's more is, let's be real about this. This is a war on poor women. Because the very wealthy are going to be able to get abortions no matter what. They'll be able to find some doctor they have a relationship with who they're able to pay extra money to. They'll fly to a different country. I mean, at this point, abortion is legal in Mexico, for crying out loud. So they will find a way to get a safe abortion. It's only everybody else who won't be able to. So as with so many things, this issue is all wrapped up in class. What's more is that the genesis of the whole anti-abortion movement was actually started by evangelical leaders who wanted to defend the segregation policies of Liberty University. They realized that they couldn't build a movement around protecting segregation just because segregation was so passé. But abortion, there's an issue they could dig their teeth into, and so they did. The truth is that in choosing abortion, they made a good choice because to a certain extent, it is kind of hard to justify. It's hard to kind of accept the idea that there's something in the Constitution that protects the right to an abortion when the Constitution itself doesn't say abortion anywhere in its text. But as it turns out, despite the claims of the conservatives, there are lots of things that are protected or created by the Constitution that aren't explicitly mentioned as text. The Air Force, for example. The Constitution does not authorize the federal government to set up an Air Force, and yet we have one. Does that mean that the Air Force is unconstitutional? Well, I think everybody would say that's a joke. Well, we'll get to that later, though. But the reality is that I've been expecting this to happen for a long time. And you can see, really, I have a record of creating videos on this issue. And even before that, I was writing articles on Medium. And even before that, really, my political activism was largely rooted from its genesis in the pro-choice movement. In fact, when I first got out of college, one of the first campaigns that I worked for was the campaign of Evelyn Murphy for governor of Massachusetts. And central to her campaign was her pro-choice position. This is dating back to 1990, so this is not some new concern that I've had. In fact, friends of mine from college can remember my arguing that we as Democrats needed to get out and vote for Mike Dukakis for president because the Supreme Court was at issue. But so many of my fellow progressive Democrats said things like, that Mike Dukakis, he's not exciting, he doesn't kind of make me enthusiastic, I don't love him. They said the same thing about Evelyn Murphy, that she wasn't their ideal candidate. She wasn't liberal enough for them. There's always some excuse for the progressives as to why they shouldn't go out and vote. Conservatives, though, felt no such compunction. As long as somebody pledged to appoint anti-abortion justices to the bench, they'd vote for them. It didn't matter what the person stood for otherwise or what the person's personal life was like. I mean, we have proof in that and their enthusiasm for Donald Trump, who perhaps more than anybody, with the exception of Mitch McConnell, deserves credit for finally bringing this issue home. After all, 3 of the 5 justices who signed on to Alito's opinion were appointed to the bench by Donald Trump. What's more is going back historically again to that time when I was arguing to people that they should vote for Mike Dukakis over George H.W. Bush because of the Supreme Court. Well, remember the fact that one of the other justices signing on to the opinion, Clarence Thomas, was appointed by George H.W. Bush, Mike Dukakis' opponent in that election. And the author of the opinion, Justice Alito, was appointed by George H.W. Bush's son, George W. Bush. So had those progressives who were Not so enthusiastic about Mike Dukakis, a flawed candidate to be sure, but still a pro-choice one, then we wouldn't have found ourselves in this position. The first point I'm going to make in this video, then, is something that I've been arguing literally since the mid-1980s, which is that we as Democrats need to take elections as seriously as Republicans when it comes to our concern over the judiciary. I'm hoping that this decision has finally woken up my fellow progressives to realize that, well, we might not be entirely enthusiastic about the candidate the Democrats have mounted, but too much is at stake for us to allow the Republican to win. Now, as I said earlier, the abortion issue is kind of tough at times to argue because of the fact that people are right when they point out the fact that abortion is mentioned nowhere in the Constitution. And it takes a little bit of understanding about legal theory to kind of comprehend the basis that the Supreme Court has used to hold in the past, in both Roe v. Wade and Planned Parenthood v. Casey, that American women have a constitutional right to an abortion. So follow me on this for a few minutes. The Fifth Amendment and the 14th Amendment to the Constitution guarantee all Americans something that's called due process. Now, procedural due process refers to the idea that a court cannot make a decision without allowing both sides to be heard. So inherent in due process is the idea that, for example, a court needs to make sure everybody's properly notified before it can make a decision on any kind of issue. Now, flowing from that idea comes something called substantive due process. And substantive due process, contrary to the claims of the conservatives, was actually an idea that dated back to the early 1900s and was used by conservatives on the Supreme Court to protect things like the right of businesses to employ children and the freedom of businesses from the minimum wage. Now, in the mid-1930s, when Franklin Roosevelt essentially threatened that he was going to increase the size of the Supreme Court and pack it with justices who were less bound by the goal of protecting businesses at all costs, actually resulted in the shift of one of the justices to no longer favoring the substantive due process argument. And that case was West Coast Hotel Company v. Parrish. That was a 1937 opinion that allowed the state of Washington to impose a state minimum wage. Now, at the same time, starting in the 1920s, the same judicial philosophy, which held that the Constitution protected businesses from the unwarranted interference of the federal government, even though those liberties are not explicitly protected in the Constitution, also started to be used to protect other forms of liberty. For example, in 1925, the Supreme Court handed down Pierce v. Society of Sisters, which essentially held that parents have a right to make decisions about the education of their children. This is the first of a series of decisions that held consistently over the last 100 years that Americans have a fundamental right to parent their children. Then in 1942, the Supreme Court used the same philosophy in Skinner v. Oklahoma to hold that people could not be sterilized without their consent. I know it seems unbelievable to think, but here in America, that actually was allowed. And there's a prior Supreme Court decision, actually, which explicitly allowed it and said that it was good policy, if you can believe it. So that decision became part of a stream of decisions that said that people have the right to make their own decisions about their own body. Then in the mid-1960s, we had a couple decisions come down, which took that logic to the next step. In 1965, Griswold v. Connecticut held that Americans have a right to get contraception, that the state can't stand in the way of a married couple getting access to contraception. If you can believe it, that actually was outlawed in Connecticut, of all places. And then, of course, we're all familiar with the 1967 case, Loving v. Virginia, where the court held that you should be able to marry anybody you want to, regardless of their race. Well, you can see now that there's this whole judicial philosophy that has been created based upon this idea that there's a liberty, a right to privacy that's inherent in the Constitution based upon the fact that we've put restrictions on government to do things. And again, the logic is, if we've put restrictions on government to do things, there has to be some area, some protection, some boundary beyond which government can't go. And that's substantive due process. That's privacy. That's the protection of our own rights to behave as we want to in our own private lives and with our own families. Now you can see, since we've established that Americans have a right to decide when they're going to have a child, and they have a right to decide who they're going to marry regardless of their race, it's not too far a leap to say, well, wait, people should be able to decide if they're going to carry a baby to term or not. And people should also be able to decide who they want to marry regardless of their sex. And indeed, Roe v. Wade and Planned Parenthood v. Casey, which dealt with the right to an abortion, as well as Lawrence v. Texas and Obergefell v. Hodges, which dealt with same-sex relationships and marriage, built upon those prior decisions. So this is not out of left field that the Supreme Court came up with some right to abortion. It's simply part of a growth in jurisprudence where the court has established that we have certain private rights that are protected by the Constitution, even though those rights aren't specifically enumerated there. Now, what's especially scary about this decision, then, is what it says about all those other rights, which are protected by the same legal theory. True, abortion is distasteful to many people, but guess what? There are some people who find same-sex relationships distasteful. There are some people who find using contraception distasteful. There are even people who find it distasteful, based upon their religion, to accept modern medical treatment. Literally, all those rights that you have, all those things that are protected by what's called the penumbra of the Constitution, essentially this area around all our bodies within which the Supreme Court has established that government shall not step, are now in danger. And if you don't think that conservatives are going to go after these other rights, you're kidding yourself. I mean, the Alito decision was explicit in the fact that he was not saying abortion should be legal or shouldn't be legal. What he was saying is that there's not a right to it guaranteed in the Constitution, and as such, the states should be able to decide on their own. Well, in response to that, we already have conservatives talking about passing a nationwide ban on abortion. So don't think they're going to stop there. And just look at the way that they have behaved with respect to LGBTQ rights. And we even have a Republican U.S. Senator who said that we should get rid of the right to interracial marriage that's guaranteed by Loving v. Virginia. So although Americans across the country need to be concerned about the fact that abortion is essentially being made illegal across this country and might actually be banned in every state based upon federal action, the bigger picture is all these other rights that were guaranteed under the same legal theory are now also on the chopping block. Now, Alito is no dummy, and he's certainly aware of these objections that will be brought up to this ruling. As a result, he goes to some effort to try to address these objections. First, Alito makes it clear, his view, that there are only two bases for the court to recognize rights as being guaranteed under the Constitution. One is that these rights are explicitly mentioned there, which is obvious. The other is that these rights are, quote, deeply rooted in this nation's history and tradition. Alito then spends much of the decision arguing that abortion is not deeply rooted in our nation's history and traditions, and as a result should be banned, or at a minimum at least, is not protected by the Constitution. However, many of these other rights that I was talking about earlier are also not deeply rooted in our nation's history and tradition. Certainly the right to marry someone of the same sex is not deeply rooted in our nation's history or tradition, or for that matter, is access to contraception. So the same arguments that are being used against abortion in this ruling are exactly the same kinds of arguments that we can see being leveled against so many of these other rights that frankly are at this point widely accepted among Americans. Now you might say that the right to an abortion is not widely accepted among Americans, but yet polling has clearly shown that by a 2-to-1 margin, Americans do not favor overruling Roe. Yes, our feelings about abortion as a nation are complex and somewhat ambiguous. Nevertheless, we recognize that at least some access to abortion is something that's both necessary and allowed, and should be protected by the Constitution. That level of intimacy really is something that we don't want government getting involved in. So don't kid yourself by thinking that this is the end. This has already been a long video, but I could keep talking about this issue for some time because this is really a fundamental debate in our society right now. Republicans, of course, are focusing on the fact that this opinion was leaked, something that almost never happens within the Supreme Court. You see, the way the process works is different justices will kind of work with each other, and they'll each take turns drafting opinions and circulate the opinions to see who can sign on to them. And until the decision is finally announced from the bench of the Supreme Court, it's not final. So in theory, this could change. And that might be the basis for why this got leaked in the first place. For all the bluster from conservatives about how this is such an outrage, The truth is, it might well have been a conservative who leaked it. I mean, who has the most to gain by this being leaked? The pro-choice jurists might be working desperately to try to convince someone to come over to their side, or at least to come up with an opinion that's slightly less reactionary than Alito's. But by releasing the opinion as is and making it clear who is signing on to this opinion, the conservatives have basically created a situation where now it's too late for one of those five to back out. I mean, it's possible that Gorsuch, who has shown himself to be a bit of an independent thinker on the Supreme Court, or frat boy Kavanaugh, might have changed their minds. But now, by releasing the opinion as is, they're boxed in and are not in a position to do so. But the truth of the matter is that's neither here nor there, because this is really a sad day in American democracy. We find ourselves in a position where a Supreme Court, where you have justices appointed by presidents who, for the most part, lost the popular vote, and who were confirmed by senators who do not represent the majority of Americans, are completely changing a law that's been in place here in the United States for the last 50 years, and that we as Americans have come to rely upon as being a fundamental part of our jurisprudence. And they did so with glee and enthusiasm. So my only concern is what's going to happen next. Well, as I stated earlier, I've really been working for a long time on raising this issue about the court's attack on the right to abortion. Why don't you check out this video over here that I recorded some time ago talking about the court's moves in that direction. I'll see you then. In the meantime, let's hope for continued progress. Thank you.